Welcome to LexTalk Will Talk Show presented by Clickaway Creators. Today, we have Ritunjay Gupta with us. Ritunjay Gupta is a dual qualified dispute attorney. He pursued his LLM from Columbia Law School, New York, and moved on to complete his post graduation diploma in financial management from IMT Ghaziabad. Ritunjay specializes in AD, HOC, and institutional arbitration, both domestic and foreign, and civil and corporate commercial litigation. He has clients from diverse sectors, that is, health and uh, hospitality, automobiles, construction, and engineering, security, fashion, food and beverages, fashion technology, and banking and finance. He has acted for and represented several domestic and foreign corporations, private and public sector banks and financial institutes, investment intermediaries, startups, HNIs, before various domestic and international judicial and quasi-judicial fora, including the Supreme Court of India, the Singapore International Arbitration Center, and the International Chamber of Commerce. Ritunjay's area of expertise includes shareholders dispute, construction disputes, insolvency resolution, debt enforcement, unfair and prohibited trade practices, breach of contract claim, operation and mismanagement claims, and corporate restructuring schemes. There's a lot more to talk about him, but now, without any further ado, let's dive in to know more about Mr. Gupta. Hi, Mr. Gupta, how are you doing?
Hi, Raima. Very excited to be here. Thank you, Clickaway Creators, for this platform.
The pleasure is all ours. Thank you. Thank you so much for joining us today. So let us start with the first question. And first of all, I would like to know about you being a commerce grad from Delhi University. What made you pursue law as a career? And let us know about your journey so far.
Wow. So law happened by chance. I mean, as cliched as it sounds, I come from a family of doctors and engineers. I'm the first commercian in the family. So like every other commercian, I pursued my undergraduate honors degree from Delhi University in business economics honors, and then I did my master's in finance. However, my dad, he was always insistent on me getting a professional qualification. So initially, I tried my hand at CA. I cleared the entrance examination, studied till the intermediate level, but it was quite somber for me. So I left it. And then I got to know about Delhi University offering the 3-year LLB program. I cleared the entrance examination. During my LLB program, I interned extensively with the top tier law firms and with judges of the high courts. I got placed with J. Sagar Associates in the corporate field initially. I was there shortly, then moved to litigation. And that's where it all began. I caught the litigation bug. It's been, 8 years now, and I'm still as excited about the profession as I was in year one. Initially, I worked at JSA. Now I'm a principal associate at Induslaw. It's been a very exciting journey for me.
Thank you, Mr. Gupta. Thank you for answering that question beautifully. Now, I would like to know that the pandemic saw some courts begin moving towards more remote proceedings and availability. So, in your opinion, is this a sustainable way and a possible way to increase access to justice?
Well, first, let me start by commending the bar and the bench for the commendable efforts in adapting in these resilient times to these technologies. I would like to caveat my views by saying that these are limited to my field of practice, which is litigation dispute resolution. I think we're still well behind the curve if compared internationally. Judges are still hesitant to hear voluminous matters over VC. The infrastructure is not up to the mark. I mean, considering, for example, hybrid mode of functioning where one party is appearing in person while the other party is over VC, the parties can't hear each other. So even for example, for cross-examination of witnesses, you require consent of both parties, which generally never comes, which leads to a deferral. So I wouldn't say the future is bleak. There are positives to it. Of course, this has helped clients curb costs. Um, the lawyers can take on more work because they've done away with the physical limitations, and the clients can get the best resources considering they can take on more work. So yes, there are pluses as well as minuses as with every other technological change, but I am still hopeful. Whether it is sustainable or not is altogether a different ballgame because it really depends. Now we've resumed physical functioning, and I mean it really depends upon the comfort of the judges, whether the infrastructure will be updated soon, whether the lawyers will be willing to work through VC. So it all really depends upon the attitude of the bar and bench going forward. So I'm not sure, but yes, to an extent, justice, access to justice has increased. Let me just put it in a more positive tone. If you see the education sector, for example, I mean, the education sector, earlier nobody could fathom that learning could happen over an iPad. Now every household has that. So technology does benefit people. So over the years, I feel that the legal profession and the practice of law will also change for the better.
Thank you so much, Mr. Gupta, for sharing your opinion with us on this. And now I would really like to know about a complex legal issue that you have worked on. And also, I really appreciate if you please describe the complexity and tell us how you have approached it.
Well, every case has its own set of complex legal issues, and each case is special in its own way. But for the purpose of sharing here in this present forum, I would recall one case that I did some years back. It was an insolvency case. We were representing the resolution professional for an electricity gen corp, which was undergoing insolvency, CIRP proceedings. And let's call it company A. And a related entity, let's call it company B, was also undergoing insolvency. However, it was at a far more advanced stage, and a resolution plan was also proposed for company B, pursuant to which the power purchase agreements, the PPAs, were sought to be terminated between company and company B. Now, we as lawyers of the RP and the RP itself has an obligation under the code to preserve the assets of the company undergoing CIRP. So we needed to defend this. It was a new code at the time. People didn't know the contours of it. We were also rattling our minds on how to come up with a good defense. After much deliberation, I remember we came up with a twofold novel argument. One was that we argued that rights in contracts are rights in property, which cannot be done away with without due process of law, as they are protected under Article 300A of the Constitution, earlier erstwhile Article 19(1)(f) of the Constitution. And the second argument was that termination without legal recourse is barred under 28 of the Contract Act. So these are novel arguments. Of course, we made these arguments before the NCLT and the NCLAT, but they did not adequately address these arguments. And the matter went up to the Supreme Court. We were very excited about making these arguments before the Supreme Court. But in the meantime, the matter got settled, and this was never argued before the Supreme Court. Ironically, a year later, the same arguments were taken in another case, which led to a landmark judgment in the practice. And I mean, I think we are content and happy with just the validation of our argument that we could come up with it at a nascent stage of the IBC code.
Thank you so much for answering that question as well. You answered it beautifully. And You have described about the complex legal issue that you have worked on, like it was nothing for you. Thank you so much for answering that. And now I would like to know what, according to you, lies ahead in the realm of domestic and international arbitration, and how one should prepare for it.
Okay, so let me begin by saying that the legislature has given a huge impetus to institutional arbitration. With the recent amendments, you can see that. Um, Earlier, we used to see clients or big ticket matters going offshore to, say, SIAC, LCIA, ICC. Now with MCIA and the Delhi Arbitration Center, all that gaining recognition, clients, and we advise clients to resort to more domestic forums. So that's a good thing. Um, as as for young practitioners, I would say hone your skill set. Hone your skill set. You don't need to treat arbitration as a stepchild of litigation anymore. It's not an alternate to litigation. So it's a field of its own. You need to specialize. Um, if an LLM helps you broaden your horizon, gain the exposure, then do an LLM. Specialize in commercial arbitration, investment arbitration, whatever you like. Now, the erstwhile skill set of being just a litigator is not going to help during arbitrations. Also, we need to align ourselves with the international best practices, and for that, also, I would advise people to go for an LLM. It really helped me when I pursued it from Colombia. I'm sure it will help others as well. Um, I would also say that the world is becoming flatter, right? Uh, Indian law is not going to be looked at in isolation in international arbitration or even in domestic arbitration now with interpretational issues on various key issues. So one needs to look at the international laws, the international best practices, IBA guidance, all that. So one needs to broaden the horizon and hone their skill set. I remember, I would like to share this. So while I was at Columbia, I attended a seminar by Harvard Allen. She had used technology, the blockchain technology, to come up with a software called Arbilex. Arbi, so how councils use Arbilex is that Arbilex has developed a database of majority arbitral awards of the AAA, the American Arbitration Association. And through that, councils can determine how um, various arbitrators would react or lean towards various issues. For example, jurisdictional issues on res judicata. How would an arbitrator generally take? What is the view that he's generally taken in the past? So that really helps. Councils have been resorting to Abilex uh, since the last few years now. So these technologies, I mean, in India, we haven't even heard of such technologies or getting used to legal tech. So people need to open up and get some more international exposure. So that's my advice to young practitioners.
Thank you so much. I am sure these tips are going to help a lot of budding lawyers and a lot of other people that are pursuing law these days. And last but not the least, I would really like to know that time is money in any profession, and in legal, it's most of all. So, how do you ensure that the best of your time as a legal lawyer?
Wow, this is a tough question. I don't think I make best use of my time. But so my mornings are generally spent on the iPad reading up on current affairs. My meals are mostly in front of the TV listening to the news, not the typical news channels, but relevant news. Uh, I have now started being driven around and I save up on time wasted in traffic. During that time, I read up. So all my files, all my files are synced up to all my devices. So they are accessible to me even during my car ride or even in court. So whenever I have some idle time, I read up on cases or deliverables or assignments or just drafts that I want to review. Uh, in terms of scheduling, I'm a little more conscious scheduling my time during the day. So if there are client meetings and team discussions, then I generally schedule it during the day when there's a hustle, bustle, and chaos in the office. Whereas for crucial drafting work, I usually keep it a little later in the night when I have some alone time to avoid the distractions. Um, Apart from that, even wherever, like for example, court, if I don't have court the day on a given day, then I would usually go to office in non-peak hours. I would work hybrid. I would work early morning at home, and then non-peak hours I would travel to office to save up on time lost in traffic. So I mean, these are small things that I generally do to save up on time. Apart from that, I mean, what is okay? Time is money, of course. I mean, that's as cliche as it sounds. But for me, time saved is also time I can spend elsewhere with family, right? And that is equally important. So, I mean, I make it a point that I spend adequate time with family, with cousins, with friends, having a life outside of work. It really helps keep the balance. So yeah, no, I mean that's how best I can make use of my time. I hope I'm doing good in that sense.
Absolutely, absolutely, Mr. Gupta. Thank you so much for sharing such great insights with us. With this, we have came to an end to this amazing session. We look forward to have a chat with you again in the future on some other legal trending topics on the international legal world. And for our viewers, if you like this chat with Mr. Ritunjay Gupta, please like and share this video and also subscribe to Clickaway Creators YouTube channel to appreciate what we do. And we have more content coming up right for you from the international legal world.